This meeting of the Anderson Township Board of Zoning Appeals is hereby called to order. This board was established pursuant to section 513.13, or 519.13, of the Ohio Revised Code by the Anderson Township trustees to provide administrative relief to any person or entity adversely affected by the Anderson Township zoning resolution. Will the secretary please call the roll?
Mr. Nye.
Here.
Mr. Halpin.
Present.
Mr. Sion.
Here.
Ms. Barlow.
Here.
Mr. Lawrence.
Here. Thank you for coming to this meeting of the Anderson Township Board of Zoning Appeals. Please be aware that this meeting is audio and videotaped and may be carried live on television. First, I'll outline our procedures. A summary of the appeal is presented by the staff. Then the appellant will present its case. The board members may then ask questions of the appellant. After that, all persons supporting the appeal will be permitted to testify one at a time after being recognized by the chairman. When those persons supporting the appeal are finished, those opposed to the appeal will then be permitted to testify and/or ask questions of the board after being recognized by the chairman. All persons wishing to testify, whether for or against an appeal, may only do so after being sworn in. When testifying, each person must come forward to the podium after being recognized, speak into the microphone, and state their name, address, and any affiliation to the case. All persons testifying will be limited to 4 minutes unless a board member requests additional time. All testimony is given to the board only. No comments or questions are to be directed to the appellant or anyone else in the audience. The board will only hear new, non-repetitive evidence or questions. Should someone wish to show support of previous testimony, they may do so by following the testimony procedures and stating their support of previous testimony. Now, will all persons who may give testimony this evening please stand, raise your right hand, and swear or affirm? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Approve the minutes.
Agenda first.
Are there any changes to the agenda?
None from staff?
We are not hearing case 14 on the PUD on Clough Pike, right?
That is correct. They will be hopefully bringing one in December.
Okay.
Or-
Motion to approve the agenda as modified.
Second.
Mr. Nye.
Aye.
Mr. Halpin.
Aye.
Mr. Sion.
Aye.
Ms. Barlow.
Aye.
Mr. Lawrence.
Aye. Are there any changes to the minutes?
None from staff.
Motion to approve the minutes of the October 2nd meeting.
Second.
Mr. Nye.
Aye.
Mr. Halpin.
Aye.
Mr. Sion.
Aye.
Ms. Barlow.
Aye.
Mr. Lawrence.
Aye. Please read the summary case for 24-2025.
Thank you. So case 24, 2025 BZA, the applicant is Emily A. House, is that it? A House on behalf of Mary Jo and Richard E. Cleveland, which are the property owners. This is at 7774 Glen Eden Lane, book 500, page 220, parcel 737, and it is zoned a residence. It is a conditional use request for a granny cottage or accessory structure, which is size 22 feet by 30 feet per Article 5.4 I-4 of the Anderson Township Zoning Resolution. So the applicant is proposing for the construction of a granny cottage 22 by 30 feet with an average height of 13 feet 3 inches in the rear yard. The accessory structure is going to be located off the farthest point of the existing driveway. The cottage will consist of clad in vinyl siding with the colors and finish mimicking the existing principal structure. The home itself was constructed in 1987. In 1996, Mary Jo Shekels transferred ownership to Mary Jo and Richard E. Cleveland. And in 1988, there was a 800 square foot pool that was added to the property. We did not find any zoning certificate on our file due to its age, but it is noted by the Hamilton County Auditor. And in August of 2024, staff received and approved an addition to the principal structure. This is the property that we'll be looking at. As you can tell, it's towards the end of the cul-de-sac. Here's an aerial. If you look to the left, you can see it's mostly wooded and has some vegetation. And then here's topography. So this is looking at the top, you have the front of the house. On the bottom, you're looking at the cul-de-sac. The top, you're looking from the other side of the street. And then on the bottom is the property that is across from it. I want you to keep in mind of that garage. And then this is facing where the granny cottage will be. You're going to be looking at the rear of the yard in the bottom. This is more pictures looking towards the back and also the adjacent property. And then here is just the application that we received. And then attached, you will see the plot plan and where the structure is going to be. If you look to the top right of it, you can see it's at the farthest point of the driveway and is in the rear yard. Here's the elevation plan. And then the floor plan. Findings, so general considerations, looking at 2.12D8, the spirit and intent, the conditional use would comply with the spirit and intent of the zoning resolution. The conditional use would not have an adverse effect upon adjacent properties or public health, safety, and general welfare. Protection of public services, the conditional use will not impact governmental services. Consistency with the township adopted plans, the conditional use is in accordance with the following areas of the comprehensive plan, which is the housing goal, so initiative 4.1.2 and 4.1.3, along with the initiative or the goal of quality of place in the 2022 comprehensive plan. The property is also designated for single-family residence use on the future land use map, which was updated and approved in the comprehensive plan update, and staff believes that the proposed granny cottage is consistent with this classification. Looking more at the granny cottage itself, so Article 5.4 I4, we've got criteria N, the architectural design and site layout of the structure and the location, nature, and height of any walls, screens, and fences are to be compatible with adjoining land uses and the residential character of the neighborhood. We found this to be compliant. The proposed granny cottage is situated in the rear yard at the end of the existing driveway, meeting required residential accessory structure setbacks with a 6 foot 8 inches setback from the side yard and 107 foot from the rear yard. Looking at P, the signage shall be regulated as follows. No sign shall be erected except those exempt under Article 5.5 D3. This is compliant. There is no signs that are being proposed. Looking at criteria CC, coverage of the required rear yard by the accessory unit shall not exceed 10%, and coverage of the entire lot by the accessory unit in the principal unit shall not exceed 20%. This is compliant. 10% of the required rear yard area is 665 square feet, and the proposed accessory structure is 660 square feet. Additionally, combining the lot coverage of the accessory structure and principal structure totals 8% of the lot coverage, falling below the 20% limit. DD, the unit shall contain a maximum of 900 square feet and not exceed 15 feet. This is compliant. The cottage will be 660 square feet and 13 feet 3 inches in height. And then EE, the terms of continuation of this use and those under which it shall eventually be removed or terminated are to be specified in the application and contained within the approving resolution. This is compliant. The applicant had clearly outlined the terms of continuation and termination for the proposed accessory structure. Staff recommendations. So to ensure ongoing compliance, we believe that upon the cessation of occupancy by Mary Jo and Richard Cleveland, the accessory structure shall no longer be used as a separate dwelling unit and shall revert to an accessory use incidental to the principal structure. The accessory structure shall not be leased, rented, or otherwise used as an independent dwelling unit separate from the principal residence. 3, consistent with plans and letter received on October 15th, 2025. And 4, construction started within 1 year, completed within 2 years. And then here's the standards.
Are there any questions from the board? Will the appellant or the appellant's representative please come to the podium, speak into the microphone, state your name, address, and any affiliation, and present your appeal?
Good evening. I'm Emily A. House, 7774 Glen Eden Lane. Can I confirm, do I have 4 minutes as well? Or do I have unlimited? Because I didn't prepare with the time.
No, you're fine.
Okay.
Go ahead.
Okay, just wanted to make sure. So I'm Emily A. House. I'm the daughter of Mary Jo and Richard Cleveland, who own the property. Mary Jo built the residence in 1987, has lived there continuously since. It's the house that I grew up in. It's been a great house, great neighborhood. They don't want to leave, but as they age, it's not a great house for this stage in their life. It's 3 stories of living. It's a large yard. It's a pool. It's a lot to maintain. They've looked at other options in Anderson Township. There's not a lot of true single-story living nearby. We looked at a possibility to do an addition, and that was referenced by staff. We did get a zoning certificate for something that would be similar, kitchen, laundry, bedroom, bathroom. And when we went out to bid that proved just economically infeasible based on construction costs, but that was an alternative with the similar net effect that was permitted by right that we explored first. We're now working with Keystone Tiny Homes on this detached accessory dwelling unit, granny cottage. The basics have been presented. It's 615 square feet. It has a bedroom, living room, bathroom, laundry, so really complete housekeeping facilities that will provide independent living for both families. While we're right next door, we can all help with maintenance and be right there as needed. The placement's at the end of the driveway, really, because that's the only place where you can get that true single-story accessible living on the property with the grade and the stairs through the house. You couldn't place it further in the rear near the pool. The materials and detailing are consistent and compatible with the detailing found on the single-family residence. We did provide extensive analysis in our application, so I'm not gonna read through all of that, and staff did a great job in the recap. But we did find, I'll read some of the highlights. We did find that it's consistent with Article 212D8 in terms of being consistent with the spirit and intent of the code. The property is remaining a single-family dwelling occupied by one multi-generational family. And we meet all of the development standards, so it's consistent with the spirit and intent of the code. In terms of adverse effects, my family of 4, we moved into this house 10 years ago when we moved to Cincinnati, and we were looking for our own house. So the 6, and then we recently moved back this summer as we sold our house. So the 6 of us have easily lived in the property in terms of cars parked in the driveway and occupancy in its current form. And this will just allow the same number of people to live on the property in a manner that better fits both of our needs. Let's see. In terms of adverse effects just from the construction, the 2 closest properties with the most likely adverse effects are 7778 and 7784. 7784 has landscaping and 2 driveways that buffer it from the construction. 7778, there's a substantial grade change down the hill and significant landscaping and distance from that structure to the granny cottage. So we don't see any potential for adverse effects to those 2 most immediately potential impacted neighbors. We've talked through the project with both of them, and neither have expressed any concerns. There's minimal tree and landscaping removal, just the minimum necessary to build the granny cottage. And we did find, as staff noted, it's consistent with the goals in the 2022 comprehensive plan in terms of housing and quality of life. This will bring a new diverse housing type to the township. In terms of the specific conditional use standards, we found it consistent with 54HN, P1, CC, DD, and EE. In terms of the architectural design and site layout, they're compatible with the adjoining land uses. It's located in the rear yard. It's substantially set back from the street. The design is subordinate to the single-family residence, but compatible with its architecture. And it does have similar massing and placement, as was pointed out, to 1-story garages that are found throughout the neighborhood, so really similar to the existing built streetscape. There's no signs. We meet, or actually are under, the lot coverage requirements, the maximum square footage and the height. And in terms of the continuation of use, This is intended to be a permanent structure in terms of it is a significant investment in the physical construction of the structure, but it is really only intended to be a principal permanent residence for the time that Mary Jo and Rich are living in it. When they are no longer living on the property, it's our intention that it would be just an incidental accessory structure to the single-family residence, similar to a pool house or other small accessory structure that you find accessory to a single-family dwelling. We understand just by nature of the definition of granny cottage, it has to be related individuals in both units. We have no intention or understanding that we could rent it out or use it for other, as a separate dwelling unit in the future. So we're amenable to all of staff's recommendations for conditions. And we are happy to answer any questions.
Any questions?
There's a basement shown on the design, but you talked about single-family living.
It was really, when construction costs came back, it was either a retaining wall or just an unfinished basement for storage, and the cost difference just made sense to have that unfinished basement for storage.
The door on the side is the only access door,
Yeah,
right?
it
I don't see
doesn't-
any
there's-
like windows below grade or anything.
That's correct.
Okay. Any other questions? Thank you.
Okay, thanks.
We'll now take testimony from those persons who support the appeal. Remember, you must first be recognized, come to the podium, speak into the microphone, state your name, address, and any affiliation to the case.
Hello, my name is Pat Fredette, F-R-E-D-E-T-T-E, 7784 Glen Eden Lane. I don't recall the word used, but of the two homes discussed, we are one of those two homes in closest proximity. There are two things that jump out at me for something like this, and I don't work in the zoning world, so I'll just speak in plain basic terms. If you're on a piece of property and someone moves in and they do something to their property that's adjacent, you want it to make sense and you want it to not have an impact. In both respects, it's perfect. It doesn't have an impact for us, even though, again, as feet were measurers, we are probably the closest in proximity. There's no physical impact, there's no side impact, there is zero that I'm concerned about. And I know I can't speak on behalf of the neighbors that live between us on the private drive, but they're very good, close friends, and we've spoken many times about it, and they certainly feel exactly as I do. The other piece that it makes sense is, I'm surprised, presumptively, this is one of the first incidences in Anderson Township to approve something like this. I think it's such a wonderful idea from a public policy standpoint to be able to have the luxury of having a physical space that large and without impact to those neighbors that are physically close to you, and yet be able to build a residence like this for parents to age in place. What a gift, what a wonderful thing, and I certainly applaud that too. I'll be glad to answer any questions.
Just to clarify, is that, looking at the picture there, your house is the one above it there?
Correct, yes.
Okay, thank you.
Thank you.
Would anyone else like to speak in favor? Now we'll take testimony from those who oppose.
So Stephen Crowley, 7735 Glen Eden Lane. So we are in that picture in the cul-de-sac, the house that you can see, that's probably us. So first off, I understand why they are doing this. I have elderly parents, I've been through all this as well. But my fundamental concern is, are we open up Pandora's box here to things that could lead to many other subsequent changes within the neighborhood? There have been attached buildings that people have added to their houses. The key word there is attached, not detached. You know, so people have added on additional garages, they've added on to their existing structure, but they look like they're part of the structure that is there today. Okay, and so that's one key point, is this is detached, it's not attached. So it looks like a separate single-family dwelling. Okay, so that's a key point. And, you know, what other types of single-family dwellings could come down the pipe later on? As far as the design goes, I don't believe it's consistent with the existing house. From the street, the existing house is brick. This would be siding. Okay, the back of that house has siding, but from a frontage perspective, it's gonna look totally different. And if you look at the other houses where people have added on, they've been very consistent in the design and look of what they've attached to their existing structures. So that piece of it, I think, is considerably different. So also concerned about what would happen down the road. It sounds like there has been a caveat added in here that once the original occupants would leave, it would go to an accessory building, which is more like a shed, which frankly, it's more like a large shed in terms of its space. 20 by 30 is not a very big occupancy residency anyway. So that's, and the final thing I would just say, this is really a first of a kind. This is not something that I believe has been done anywhere. So I would ask you guys that question. In Anderson Township, have you had tiny homes that have been approved anywhere at this point?
I can tell you that my memory is that we've done at least one of these maybe a year or so ago, kind of off of Clough on maybe Harcourt or something like that. Does that sound, or Anderson Cove over in that direction? Does that sound right?
Is it in a subdivision?
Yeah, you know, one of those streets that's probably 15 houses on each side, you know, on the north side of Clough, I think. It's the only one I can think of, so there haven't been many, but I think, am I remembering that right? You're looking at me like I'm wrong.
I think, excuse me, that was the worst time for my throat. I think if that's the recent one you're thinking of, I think they withdrew their application. I can't remember if they had a hearing or not. This, from my case logs that I looked at.
I'm remembering a cul-de-sac, and then like it was, the hill was a little bit down, the house was a little bit down the hill on the cul-de-sac. Kind of like I imagine yours, I don't know if you go down, but like on that part of the cul-de-sac. Does that ring a bell to anyone?
Yeah, it does. I remember that.
But maybe there wasn't a hearing on it all. That's a little hard for me to remember.
We can check the case logs while we're talking, but I think
we certainly agree that it's not, doesn't come up often.
Right.
no, it's
Right. So again, fundamentally concerned that it's detached, it's not attached. I don't feel like the design is consistent with the existing structure. Worried about what could come next, both in terms of just the general subdivision, but also when there's turnover. And I think it's, you know, a first of a kind thing. A tiny house is not consistent with the type of houses we have in that neighborhood. That is non-debatable, I think, at this point. So that's kind of why I'm very concerned about it. Thanks.
Thank you.
If it were just a detached garage, would you have a concern about it?
Yeah, if it was a detached garage, I would have a concern about it. You know, some people have sheds, that's one thing. If they built garage, they've made them attached, so it looks like a consistent structure. I mean, it doesn't look like two different buildings. So this is totally separate. Totally separate design, totally different construction. A lot of things that are different from the existing structure.
Okay. Thanks.
Thanks.
Would anyone else like to speak in opposition? Come to the podium.
Eric Alland, 3050 Williams Creek Drive. Excuse me. So my biggest concern is there's a covenant for this homeowners association approved by 90 people. We all got it when we closed on our houses. It is very specific. No building or structure should be erected, placed, or permitted to remain on any lot except for one single-family residence, not to exceed 2 stories. No structure should be erected, placed, or permitted to remain on any lot. Structures is defined. I can provide this as evidence if you need it as evidence. You can put a shed on our properties. It has to be less than 72 feet. You can build a garage on our properties. It has to be attached. They cannot be detached. So this is in direct violation to the covenants of the 90 homes. That being said, other than the 12 families that drive past the sign that's been up, the other 80 families have no idea what's going on in their homeowners association right now about this piece of property. So I have concerns about that as well. Not necessarily a zoning problem, maybe a homeowners association problem, but there is a huge majority of people live in this community that have no idea what is going on. That being said, these covenants were accepted back in 1989 in the Hamilton County Engineers. I have the notarized copies of it. And if for some reason this does get approved tonight, I'd request an immediate injunction until the homeowner association approves, because by state law, section 5312-13, we can proceed with compliance with covenants and proceed legal action against this home. Again, if approved, I'd also say structure should be removed after the Clevelands depart, because there should be no permanent structures on this property per the covenants. That's all I have to say. Any questions?
Have you raised this with the homeowners association?
I did. The president ignored me. The treasurer said he saw the sign 2 weeks ago, didn't spread the information. I spread it to the people on my lane. I'm not in this picture. Those 12 families had no idea what was going on with this property. Multiple of them spoke up. They have commitments because I talked to them 2 days ago.
We're not a court. We can't issue an injunction. We have no jurisdiction over homeowners regulations. If we approve this and the homeowners association says they can't do it, that's between you and them and the homeowners association. We have no authority over that whatsoever. So I appreciate your concern, but we can't help you. So I just want to make sure you know that.
All right. So I just find it odd that the zoning commission wouldn't take into consideration the compliance and the covenants of 90 homes that have been closed and documented and legally authorized, and I'll approve those covenants.
Yeah, I mean, like the code is pretty specific about what we need to consider. You know, is this consistent with the zoning plan? Is this, or does it meet the signage requirements? You know, does it meet the rear yard size requirements? Like, these are, all the things are spelled out. HOA compliance is not one of them. That's just not a township zoning thing. I'm not saying it's not important. I'm not saying you're not right. I'm saying that's not what we do. So I can't help you on that is all I'm saying. I'm not arguing with you about it. I just want to make sure you understand that, because if you think you have other rights and you need to enforce them, you should, but we can't. I just want to make sure you know that.
All right, that's fine. And then I guess the only recommendation, though, if you will approve it, is that the structure is torn down after the family leaves, so it can't be used by another family down the road as another residence or an Airbnb or anything like that.
No questions?
Thank you.
Is there anyone else that would like to speak? Hearing no further comments, if there's no objection from the board, close the public hearing on case number. Oh, would you like to respond? I'm sorry.
Hi, my name is Karen Crowley. I live at 7735 with Steve Crowley. Part of the documentation says that the value of our homes will not decline given this property that's going to be built. And my question is, how do we know that? First of all, there's nothing that's been built in Anderson Township. So what are we comparing to know that a separate structure on a very nice neighborhood is going to cause the values of our homes to go down? That's one of my concerns. The building that's being built will be clearly seen by the street. They're saying this is in the rear of the property, but it will be seen clearly by the street, if you're on the street. If I was someone that was looking through that neighborhood to purchase a house, and I saw that extra building on that property, I would hesitate whether to live in that area, because who knows what's the next structure that's going to be built. You know, there's a lot of different opinions out there, and if once a building is built like that, who says others can do it? A lot of the homes in that neighborhood are larger acreage homes. Many people can put additional buildings on their property. Ours, for one, we could clearly do that. So I'm just asking that you take that into consideration. Do you have any questions for me?
Thank you.
Thank you. Emily A. House. I think I would just reiterate the overall use of the property is not changing. It will remain consistent with the definition of a single-family dwelling, just with the addition of another detached structure on the property. I think the very nature, the township has approved the granny cottage as a conditional use, throughout the township. So the fact that others, whether or not others have been built isn't really material to the case. It is whether or not we meet the standards of review for the granny cottage. And I think the material selection is in part to kind of maintain the prominence of the single family dwelling and have that still be the prominent streetscape feature. Both the placement and the materials, it's more of a diminutive structure towards the rear of the property, clearly differentiated. But yes, I think just inherently by the nature of the granny cottage, it can't be rented out. It has to be related people living in both units. So I think there's that inherent protection by the code, no matter, a future homeowner should do their due diligence and understand that that's what's permitted here. So I don't think there's a fear that, when we leave the property, it is very clearly articulated in the code, so that would remain in the future. Any other questions?
The HOA issue, you understand we don't have any control over
Right.
that.
I think that's, this was the first time we were made aware of it. We've talked to many people in the neighborhood about our plans. We put packets in the mailboxes of everyone in the cul-de-sac to come to us and work
You guys aren't
with us
allowed to speak while the applicant is speaking.
through questions, so that we didn't wind up in this place. But I think it would be our understanding that the HOA regulations would be a separate private property owner dispute that we'd certainly work to resolve if there is an issue there or a conflict. But I think inherently it is remaining as a single family use. It's by nature of the township zoning ordinance.
I guess what I'm saying, just to be clear, is if we say, yes, you've met the criteria for a conditional use permit, and your HOA says, no, you can't do it, like, you can't do it, right?
Right. I mean,
Okay.
I think that would be, yes, we would have to work
All right.
that out. We understand that. Yes, that's
Okay.
the next step.
Right.
Yeah, but they're two separate issues.
Separate issues, right?
Yep.
Okay.
Thank you.
Mr. Chairman, with respect to case 24, I move that we close the public hearing.
Briefly.
So do you have the ability to go to the website and show something? Okay, well, regardless of that, can you bring up the picture that showed the front of their house? That's the front of their house. What is that made of?
I'm sorry, what'd you ask?
What does their house look like? What are the building materials?
You have already stated what it's made of.
Brick.
We don't need to tell you.
Brick and shingles, okay. So if you bring up the plans for the proposed structure, do you see any siding on that original picture of that house? Answer is no, I believe. This is purely siding. There's no way that looks consistent with the existing structure. So one of the key criteria here is no adverse effect anticipated upon the, adjacent properties. And I would argue there's a significant issue here in terms of a discrepancy between the designs, sizing and so forth. That's what we're arguing. It's detached and the design is not consistent at all. Thanks.
Are there other houses in the neighborhood that are sided rather than brick?
Cedar,
Cedar siding.
yes, but when they built something on, like an extended garage, they built it the same as what that house is. So people that added on to their houses were consistent with what the house is made out of. If it was brick, they added on brick. If it's cedar, they added on cedar. This is brick and they're adding on a detached property that is vinyl. And it's much smaller.
So if they made the front of it brick, you would be okay with that?
If they attached
Just
it,
out of
if they're, the original plan
hypothetical.
that they said that they had of an attached structure, which was likely, I don't know, if that was consistent materials, that would have been fine.
Okay.
Thanks. May I briefly say one comment, and I apologize.
One more, and that's it.
What's this guy's name?
Patrick Fredette, 7784 Glen Eden Lane, the most adjacent neighbor. It's an awkward presentation to be here because some folks are friends but you know, it is understandable that we would have disparate views, and I get the concern about the hit on values and all that stuff to the property. As you know, from a practical standpoint, the staff wouldn't have recommended, as I understand that they did, the property or the structure, at least relative to its compliance with those criteria you have to pay attention to. So independent from that, it boils down to the hit, like I said earlier, and the sort of generic public policy good in this thing. The hit, you know, as the closest neighbor, who does have siding, by the way, as the closest neighbor, I think that I am, I have zero concern. It may increase in value. I did live in a community outside of Ohio for many years where these structures were fairly common. And there were use restrictions on them that were fairly consistent and limited relative to use for renting and things like that, really just restricted to family members. Always seemed like a really good practical model to me. And so I really do think from a public policy standpoint, this is a wonderful, wonderful thing that should be embraced. Thank you.
Thank you. Close the hearing.
Mr. Chair, I move that we close the public hearing in case 24.
Second motion.
Mr. Nye,
Aye.
Mr. Halpin,
Aye.
Mr. Sion,
Aye.
Ms. Barlow,
Aye.
Mr. Lawrence.
Aye.
I guess the first thing I would say is that if I were the applicant, I would make sure I had HOA permission before before I even got this far, but either way, they should do that. That's not legal advice, that's just a suggestion. I think we've heard some concerns from neighbors about the detached nature and the appearance of the structure. And so I went back and looked again at the criteria that we need to consider. And so one of them is from Article 5.4 I4N. And so the actual text is, oh, it's right here. Here it is, okay. The architectural design and site layout of the structure and the location, nature, and height of any walls, screens, and fences are to be compatible with adjoining land uses and the residential character of the neighborhood. So that does not mean that it must be made out of the same material as the house. It has to be compatible with adjoining land uses, residential, and must be compatible with the residential character of the neighborhood. So we're talking about vinyl siding, as is common on residential structures, and apparently even the neighbor's home. Doesn't match the principal structure, but it certainly is consistent with the residential character of the neighborhood. So I just want to make that observation. That's one of the criteria to consider. Signage, no signage, right? The next one is coverage of the yard, et cetera. It meets those meets those requirements. DD is 15 feet high, no more than 900 feet. It meets both of those. And then, you know, sort of the use and termination of the use have to be specified. You know, we can impose those conditions, of course, even if they weren't specified. And, you know, if anyone ever uses it in violation of those conditions, you know, the staff can issue a complaint and there's a legal procedure to enforce that and so on. So all those seem to be covered. The other criteria, so those were the specific considerations. There are these general considerations, right? And so from Article 2.12 D8, one of the general considerations is whether the conditional use would comply with the spirit and intention of the zoning resolution and district by meeting these standards. So one of the standards is, would it have an adverse effect on adjacent properties or the public health, safety, and general welfare? So this seems to be the big one, right? Like, protection of public services, not an issue. Consistent with adopted township plans, yes. You know, we don't make policy here, but the trustees have said the policy is we should have a diverse set of housing options and so on. So I think it's consistent with the adopted township plans. The question is really, would it have an adverse effect upon adjacent properties or the public health, safety, and general welfare? I don't see anything here that suggests it would have an adverse effect on public health. I don't see anything that suggests it would have an adverse effect on safety, you know, adjacent properties or welfare. I guess it comes down to, do we think that a granny cottage that is detached from the main structure by, let's see the dimensions. If I'm understanding it right, it's 12 feet away on one corner, kind of, and, you know, 8 feet away on another corner, or something like that. There's a 3 and a 5 and a 3 and a 9. So very slightly detached. If that would have an adverse effect, whereas an attached structure, you know, could be essentially the same, you know, bump it over a couple of feet. Or a detached shed that's used for a different purpose. You know, is it really any functionally different from that? I mean, it's hard for me to see how it is. So I think my judgment is that it's hard for me to see how this would have an adverse effect on adjacent properties. I hear the neighbors saying they're not thrilled with it. I hear other neighbors saying it sounds great. It's just hard for me to see how this would have an adverse effect upon adjacent properties. So I think it really meets all the criteria, and I think, subject to the recommended conditions, I'd probably be in favor of granting it, but certainly open to being persuaded by what everyone else has to say.
And you got a tree out front that's gonna block the view of it, pretty much.
Flip to that.
At least from this perspective.
Yeah,
So if I'm looking at this right, it's not going to be where the truck is. It's going to be, go back 1, 2 pictures. It's going to be more over here
Yeah,
than
closer
here.
to the house.
well, it's going to be.
If it's only 8 feet off the house, it's got to be like right there.
Yeah, and it's 20 feet, 22 feet
Yeah.
wide. So
Is
I
this
don't
the
know.
same house?
It's probably gonna.
I think that's the back.
It's closest to the property line. It's a little under 7 feet, and the property line runs very close to the other driveway, right?
Yeah.
So it'll come all the way over to where the truck is. It'll
Yeah.
be, you know, from the truck and to the left, I think. Again, set back from the back of the house a little bit.
And I think that tree kind of blocks the view of it somewhat.
Yeah, I mean, the tree that's in the shadow here is in front of the house, so if you're on that side of the house, you don't see it quite as much, I guess.
And a location anywhere else on the lot is not doable due to the pool and topography and everything else. So really, that's the only place to put it.
Yeah, I mean, I understand every neighborhood is different. Every street is different. My street is a little different from this street, but, you know, I've got 1, 2, 3, 4, 5 parcels that adjoin mine, and 4 of them have essentially what could be a granny cottage. It's a shed or a garage in these cases, but, you know, if you took off the garage door and put on a walk-through door, it would look exactly like this is going to look. So it's hard for me to see how that has an adverse effect on the neighborhood.
Just make note too, that lower right picture there, that looks like it's got siding, some sort of aluminum or vinyl siding on it.
Mm-hmm.
So it matches in that sense. I understand the front of the house is brick. If that were a major concern amongst the board, you could even ask the appellant if they would consider putting brick on the front fascia of the cottage, and then siding on the rest kind of to match the back of the house would seem also appropriate. Something to consider.
I'm surprised the HOA hasn't said anything. I'm surprised by that, because I feel like this would be a big sticking point.
Me too.
Especially since they're aware.
Right. So I don't know what that means, that the HOA guy, president, was unresponsive or didn't take the time to.
Be concerned.
Right,
Yeah, I don't know.
yeah.
I mean, I guess I wouldn't be surprised if it caught their attention eventually.
Right.
I don't know. They're not here either way. I would think.
And as you mentioned, it's not really within our purview to
Yeah.
consider that's a civil matter for a different court.
With respect to, you know, a condition that the front be brick or something like it, I mean, I don't think I would feel differently about the application if that were the proposed design. And so I think what I would say is, you know, one of the recommended conditions is consistent with the plans dated October 15th or whatever. Yeah, 15th. And so I may say the condition could be, you know, consistent with the plans and letter dated October 15th, or alternatively, you know, with a brick facade on the front, you know, like, I think that could be an acceptable deviation from the plans if they wanted to go that route and maybe try to accommodate some of their neighbors' requests, but I'm not sure. I just don't think it should be required, I think. So I think, I don't know, I think I'm in favor of it for all the reasons I've explained. Does anyone want to convince me otherwise? Nobody likes to convince me otherwise.
Well, let me just ask another question, and I know you said like the whole HOA thing, but like if this gets approved, do they go to the HOA to say we're doing this, or you can bypass it?
I mean, I don't know what they'll do.
Yeah.
I know what I would do.
They could shoot it down, or.
Yeah, I mean, like, HOAs, boy, they can get you. And I think,
Right.
you know, you could have the thing half built and the HOA could come in and say, no way,
Okay.
and take you to court over it. And I think, I don't know what the bylaws say. I'm not the ultimate interpreter of the bylaws, but I would be pretty shocked if anyone, for example, tried to take a conditional use permit to the HOA and said, we must be allowed to do it because the BZA said yes. I think the HOA would say, get out of here with that. And I think if it went to court, a judge would say, get out of here with that. So I don't think they can backdoor their way into it if we approve it, if that's what the question is.
Okay, yeah.
Yeah. But again, I don't know what the bylaws say, and maybe it's, you know, maybe it's permissible, maybe it's permissible, maybe it's not. Yeah.
Anything else? I don't think so.
All right, with respect to case 24, I move that we grant the conditional use permit subject to staff's recommended conditions with the modification of Exhibit 3 that would permit the applicant to put on a brick facade at their option.
I'll second the motion.
Mr. Nye,
Aye.
Mr. Halpin,
Aye.
Mr. Sion,
Aye.
Ms. Barlow,
Aye.
Mr. Lawrence.
Aye.
We will be in touch with next steps. Thank you.
That's an HOA problem.
Eli will get the resolution ready and then we'll review.
Been the first step. Yeah, because I think they pay.
Yeah.
Usually I'm kind of like, okay. Okay.
Nice view. That was Italy, wasn't it? Looked like the coast.
It's not Cincinnati.
We've got some nice views.
No, I appreciate Jeff, like, right, going through that and like, checking that off. That's good.
They have a lot of lemon trees along that
Yep,
coast.
thank you.
Yeah. You've been there? Just a year ago or so.
Oh, no,
2 years ago?
it's been a while since I've been to Italy. Well,
The-
a couple of years ago, we were in Sicily.
Sicily, okay.
Yeah.
Resolution's ready for your review?
I just remember singing the song, and when I got off the bus, lemon tree, very pretty. It's embarrassed my stepdaughter.
I'm good with this so far. In the last sentence of the first paragraph, can we say the adjacent property at 7784 Glen Eden Lane, comma, and other properties, comma, will likewise remain? 'Cause I think it's, certainly those two are primarily screened, but others are as well, I think. I'm good with all of this.
Okay, I know they said like if they move out of that dwelling, then it'll be used as like a pool house, I'm like, or a pool shed, I'm like, that's a hell of a pool shed.
I don't know what they're gonna do at that point. At that
Yeah,
point, they should
jeez.
expand the whole house, and I don't know.
this
I don't
one?
know.
Interesting.
Just I sell it on this. Oh,
Is that text getting tinier or?
That's what I was.
we were all trying to figure it out.
What is happening here? That's fine. Am I losing
There
my
we go.
mind?
Would you like the font to be larger in the resolution?
I would, or zoom in at least for me. Come on.
I unplugged it. I ran out of ports. Yeah, you can't touch it. Did we agree that it needs to be 12?
I think it should be 12,
Okay.
maybe 14.
Since we have a consensus. The rest of it's 12. I'm sorry, were we good with everything above that?
I was.
Okay. What do you need? Yes, you had the clicker. You said something. Oh, that's on me. Yeah. They only gave me 3 plugs, and I got all 3 in.
I'm good with all this.
Yeah.
I think I'm going to over-lawyer this here. Doesn't sound like me, does it? Should condition 1 clarify that, like, as long as at least one of them is still in there, that it's fine?
Yeah.
Yeah, 'cause
You want
if-
and or? Just or?
No, actually, I guess maybe I wanted and after all, and I have to really think about it. As long as at least one of them's still in there. If the test is cessation, and you have an and they both
Either
got to
or?
be out.
Upon the cessation of occupancy by either.
No, because that's exactly what we don't want. If one of them moves on,
Yeah. But
they should be, the other one's got to stay, right? So you don't want to say upon the cessation of either of them. The cessation of occupancy by both of them is what you need. Then it shall be no longer used. So actually, it was right the first time around.
Unlawyer that.
so upon discussion, what was the result that we came
Yeah.
to?
Back to the beginning.
Leave as is.
Yeah,
It was originally
step.
written.
So get rid of the or?
Get rid of the or.
We're gonna circle round on that. Get granular.
If you could give me the dumbed down version, that would be fantastic. Thank you.
Everyone's good with this?
Yeah.
I move that we approve and journalize this
24-25.
case 24. Thank you.
Second.
Mr. Nye,
Aye.
Mr. Halpin,
Aye.
Mr. Sion,
Aye.
Ms. Barlow,
Aye.
Mr. Lawrence.
Aye.
Before we leave, we do need a secretary, since Mr. Shekels is not here. So, would an acting secretary for this evening?
Move to nominate anyone but me? No, I'll do it.
You are vice chair, though.
Does that mean I can't be?
I have no idea.
I have no idea.
I think you
I
can.
nominate John.
Okay. And do we have a second?
Second.
Okay. And then it looks like it's unanimous. So, John, you're the secretary for this evening.
Okay,
So don't leave.
Congratulations.
so I have to stay, huh?
You get a bump in pay.
Yes.
Motion to adjourn?
Move to adjourn.
Second.
All in favor?
Aye.
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 Perfect.